Over the past 18 months, this battle has been focused on two key bills. This battle within American society, enacted by the Republican-controlled Congress, the Detainee Treatment Act 2005 and the Military Commissions Bill 2006, which both were enacted to negate landmark U.S. Supreme Court decisions. Let's look at the first of these bills, the Detainee Treatment Act, and the Supreme Court decision that prompted it. In June 2004, the Supreme Court ruled in a landmark case, Rasul v. Bush, that the Guantanamo detainees were in fact on American territory and thus deserve access to U.S. courts, prompting the country's top corporate law firms to file 160 habeas corpus cases on behalf of 300 Guantanamo detainees. Then in the summer of 2005, Senator John McCain amended the must-pass Defense Appropriation Bill with an absolute ban on, quote, cruel, inhumane, and degrading treatment of detainees, whether by the military or the CIA. The White House fought back with loopholes. First, Vice President Cheney pressed McCain to simply drop the law. Next, National Security Advisor Stephen Hadley urged legal exemptions for CIA tortures. And finally, the administration tried to neutralize the impact of McCain's amendment with another amendment written by Senator Lindsey Graham that tried to deny the Guantanamo detainees any access to the U.S. courts for habeas corpus suits. Then on December 15, 2005, all these tensions seemed to dissolve in that dramatic Oval Office handshake between Senator McCain and President Bush. President Bush announced that this landmark legislation made it, quote, clear to the world that this government does not torture. That immediate mirage concealed continuing White House moves to undercut this same legislation, using it to legitimate the three controversial legal doctrines, neoconservative legal doctrines, that the White House lawyers had devised to justify torture after 9/11. Doctrine 1, of course, is the president is above the law. Doctrine 2, of course, is there are legal loopholes that will allow the CIA to torture legally. And Doctrine 3, most important in this context, the U.S. Navy base at Guantanamo is not U.S. territory. To nullify the Supreme Court's 2004 ruling in Rasul v. Bush, this new law, as amended by Senator Graham, stipulated that Guantanamo Bay is no longer U.S. territory and, in theory, denied detainees any access to U.S. courts. In effect, McCain's original amendment banned torture, but Senator Graham's amendment to that amendment removed any real mechanism for the enforcement of this ban. If we look behind the headlines surrounding this debate, for a deeper analysis, it seems that the elusive quality of psychological torture that I cited earlier in this lecture has complicated Congress's recent efforts to prohibit the practice. Now, unlike conventional torture, as I said earlier, with its telltale physical sequelae, psychological abuse eludes easy definition. And as I said, definitions are critical in both perpetration and prevention. Indeed, right after Congress approved McCain's torture ban in December 2005, Attorney General Alberto Gonzales parsed the word severe to insist that the new law only adds clarification to Congress's existing definition of torture as, and these are Gonzales's words, intentional infliction of severe physical or mental pain. The Attorney General seemed to be echoing the opinions of Justice Department subordinates who were already arguing off the record and in the press that the torture ban by McCain would still allow waterboarding, the same method that the French Inquisition had once called tortura gallicae ordinaria, or standard French torture. When future investigators try to judge the slippery signs of CIA psychological torture, each of the Attorney General's words, intentional, severe, and mental, will open another loophole, another eye of the needle, through which the CIA can pass to continue this cruel practice. In a dramatic denouement of June 2006, the U.S. Supreme Court decided in a second landmark decision, Hamdan v. Rumsfeld, that President Bush's military commissions were illegal because they did not meet the requirement under Common Article 3 of the Geneva Conventions that Guantanamo detainees be tried, and these are the words of the court, with all the judicial guarantees recognized as indispensable by civilized peoples. Then on September 6th of last year, in a dramatic bid to legalize his now illegal policies by virtue of the Supreme Court decision, President Bush announced that he was transferring 14 top al-Qaeda captives from secret CIA prisons to Guantanamo Bay. At once repudiating and legitimating past abuses, President Bush denied that he authorized torture while simultaneously defending the CIA's use of a tough alternative set of procedures to extract what he called vital information. To allow what Bush called the CIA program to go forward, President Bush announced that he was sending legislation to Congress that would legalize the same presidential prerogatives in treatment of detainees that have been challenged by the Supreme Court. Now, at first, Bush's bill seemed to arouse strong opposition by 3 Republican veterans on the Senate Armed Services Committee, Senators Graham, McCain, and Warner. But after tense, day-long negotiations inside Vice President Cheney's Senate office on September 21st, 2006, these Republican partisans reached a compromise that sailed through Congress within a week without an amendment to become the Military Commissions Law 2006. Now, among its many objectionable features, this law strips detainees of their habeas corpus rights, sanctions endless detention without trial, and allows the use of tortured testimony before the military commissions. Most significantly in terms of this talk, by using verbatim the narrow definition, again, I keep coming back to that word, definition of severe mental pain that the United States first adopted back in 1994. This law allows CIA interrogators ample latitude for future psychological torture. This definition is concealed under paragraph 950V, Part B, subsection B, on page 70 of this dense 96-page law that reads, quote, severe mental pain or suffering defined. In this section, this term, severe mental pain, has the meaning given that term in section 2340 of Title 18 of the Federal Code. Now, what is that definition in section 2340, which we first saw back in 1994? This is, of course, the same restrictive definition of psychological torture the United States first adopted when it ratified the UN Anti-Torture Convention in 1994 and enacted enabling legislation in U.S. federal law. Simply put, this legislation's highly limited standard for severe mental suffering does not prohibit any aspect of the sophisticated torture techniques that the CIA has refined over the past half-century into a total psychological assault on the human psyche.